So this is a case that, as of the time we're filming this anyway, the court hasn't officially taken up, but we highly expect that they will take this up. And this is a challenge to what is called a TRAP law, which is a targeted regulation of abortion providers law in Texas that passed in 2013. And what these laws tend to say is things like, these are the laws that we hear a lot about on the news. The hallway of an abortion clinic has to be a certain width. A doctor has to have admitting privileges. These sort of ridiculous restrictions that are placed on abortion providers that aren't placed for women's health. They're placed to try to make it unattainable for businesses to reach all of these requirements and to put these abortion providers out of business. And so the original case was saying, well, look, this law is not devoted to women's health. It's not actually going to protect anybody. You're just trying to put us out of business. Unfortunately, the Fifth Circuit upheld these new regulations, and so the Supreme Court is likely to take up the case. They required the Fifth Circuit to put on hold the implementation of this law until they could review it, which is why we expect that they will. What's really important to note when we talk about how these laws have zero impact on women's health specifically goes to things like the question of, should an abortion provider have admitting privileges at a hospital? And the overwhelming consensus from the medical community is, well, no, it's really not necessary. It's a completely different kind of job that you're asking them to do. If there is a situation where an abortion requires increased medical care, they're going to go to another doctor who is more skilled in that particular kind of medicine. On top of that, abortion is an extremely safe procedure. It's actually safer than childbirth. And so to place this kind of restriction on abortion providers with no medical evidence really makes it clear the actual purpose of these laws. And you simply can't do that. You can't make it harder for women to get their medical care just because you don't necessarily like what they're doing. So, we're hoping that the Supreme Court will take this up in a way that is beneficial to women, but it certainly remains to be seen.
Okay.
I would only add real quickly, and that is that, following up what Hillary said, the comparison they made is that there are the outpatient type surgical procedures where the doctor's not required to have admitting privileges. Right. So why do these doctors performing this particular outpatient procedure have to have admitting procedures?
Well, right. Your dentist does not need to have admitting privileges at your local hospital, even though they can put you under anesthetic and cut into your mouth. So there's, it's certainly singling out these individuals specifically because of the
specific procedure,
the procedure that they're providing, and not because of the safety of that procedure in and of itself.
So we're hopeful for CERT.
Yeah, we're certainly crossing our fingers and hoping that it will go in a way that is good. Unfortunately, these TRAP laws are popping up more and more and more nationwide, and they're specifically designed to try to strike down reproductive freedom, and that's very, very concerning to the ACLU. So we would certainly hope that it goes in a way that is beneficial to women. It is of serious concern to all of us, however.